Hello and welcome to FFRF's Ask an Atheist. I'm Ryan Jane, a staff attorney here.
And I'm Andrew Seidel, FFRF's Director of Strategic Response. And today we're going to talk about a big win that FFRF had at the Supreme Court. But first, as always on the Ask an Atheist show, we encourage your questions. If you've got a question, please ask it in the comments below, or you can email askanatheist@ffrf.org. That's askanatheist@ffrf.org, or just ask them right in the comments below. And later on in the show, we're going to take those questions. But first, we got to tell you about the big win that we had.
Yeah, if you didn't see it, we got a big victory in a case that we've been working on for a long time. Andrew and I have been on this case. We filed it in 2015, and Andrew was working on it even before I was here.
For 3 years before we filed.
Yes.
It's been a long haul.
So if you haven't been following it, this is the case FFRF versus Morris County Board of Freeholders in New Jersey.
And it's a pretty simple case. We won unanimously at the New Jersey Supreme Court, and the U.S. Supreme Court today denied the county and church's petition for certiorari. That means they are not going to hear the case themselves. They decided, nope, the result is going to stand. FFRF's unanimous victory at the New Jersey Supreme Court. It stays. To understand the case, though, I think we need to back up a little bit.
Yeah, and we have with us today our plaintiff in the case, who is a New Jersey taxpayer who's also been working on this issue for a long time. David Steketee is with us on the show today. Hi,
Welcome, David.
Hey, guys.
So, David, you reached out to FFRF back in, was it 2012 or 2011?
2012.
2012. It was early 2012. I think this was one of the first cases that complaints actually that I got while working as an attorney at FFRF. I was working with Stephanie Schmidt at the time. She's the one who passed your emails off to me, and we started digging into this. And you, I, Stephanie, other FFRF attorneys, some of our legal fellows, we spent about 3 years digging through records and prepping this case as much as we possibly could to get it going. Why don't you give us, in your own words, what the case was about and why it was important to you?
Yeah, so, I lived in Morristown, New Jersey at the time, which is a town right down the road from where I am now in Madison, New Jersey. And I was walking through town one day and noticed a big billboard in front of the Church of the Redeemer. And it said that funds were provided by the Morris County Historic Preservation Trust. I was curious about it, and I did some research, and it turned out that it was funded by taxpayer dollars, which didn't pass my sniff test, and probably shouldn't have passed anybody's sniff test. And it just concerned me that we are providing tax dollars to the direct renovation and repair of a church building, not to buying books for school kids, not to busing kids to school, not to repair of, a non-religious facility owned by a church or a religious school, but directly to the church itself for repair of the actual church building where worship takes place. Let me
stop you right there for 1 second, because this is you. You are a Morris County taxpayer. The government is taxing you, then taking that money and giving it to churches to repair their buildings, right? That's the bottom line.
Correct.
And you happen to be an educated fellow, and you, as you said, did a little digging, and I think you read the New Jersey Constitution at some point in your ramblings there.
Yeah. The New Jersey Constitution is pretty clear. And honestly, I didn't even know that clause in the New Jersey Constitution existed, much less that it predated the federal Constitution by something like 8 years. It dates to 1775. And it says very clearly, no person shall be required to pay taxes or tithes for the repair of a church.
Yeah, well,
literally those words. And it was surprising. It honestly took me by surprise, because I originally approached the freeholders with a First Amendment argument, which I think would also, hold. But this was way clearer and a way easier argument to make.
Yeah, and it shows how on point your intuition is, that you saw that taxpayer money was going to repair the church. You thought, this doesn't seem right, and it turns out that even before the United States was a country, that exact question had come up and reached the same conclusion, that this is a problem. So what did you do when you...
Well, hang on, because this is a critical point, and it's something that I think there have been a lot of news stories that we've seen lately. It's on our victory. Some of your local papers have covered it. Was it the Morristown Green? Is that one of them that's covered it? And then we're also seeing some of the religious right organizations and news outlets and the mouthpieces for those organizations really getting out there and sort of twisting the religious liberty aspect of this case. And I really want to focus on that for just 1 second, because the religious liberty right, the religious freedom here lies with you, with David Steketee, the taxpayer. And the reason that this predated the U.S. Constitution is because this idea that the government cannot use its coercive taxing power to take money from you and then give it to a religious organization that you disagree with is one of the most fundamental religious liberty principles in America. I mean, this was a very, very basic, simple principle that our founders understood and that we are seeing eroded to a large degree today. And that's one of the reasons that we took this case and really wanted to point that out. And the New Jersey Supreme Court really seemed to listen when we got there.
Yeah, and it's very reminiscent, of course, for people who follow the Supreme Court and state church separation. This recent case, Trinity Lutheran, which came down in 2017, and that was out of Missouri, and the Missouri Supreme Court reached the same conclusion. It was a different set of facts, but in that case, they were looking at a similar state provision that says you can't force taxpayers to support churches, and they applied that, prohibited some funding, and the Supreme Court alarmingly looked at it and took the other side of it and said, no, the religious liberty right in that case was, they said, with the churches. The churches have a right. They are entitled to taxpayer funds, which is really alarming.
It is, except they also twisted the facts there and really said it laid more with the playground than with the church. But before we dive more into that, David, so first you examine this, you figured out, hey, this actually violates the state constitution, the federal constitution. You came to FFRF. So walk us through kind of what happened next. How'd that go?
So, I mean, originally I went to the, I told FFRF, listen, I want to not,
you didn't want to sue. You wanted to do this the easy way.
Go up to the freeholders without any notice, right? Yeah. So I went and spoke to the freeholders on two separate occasions. One was just hey, just to let you know, this is totally unconstitutional, and here's why. And then the second time, when they were going to award the next round of grants, I went again and said, I don't know if you heard me the first time, but it's really unconstitutional. Like, here's some more reasons why, and here's why your lawyer's analysis isn't entirely accurate and is a bit misleading, and you're looking at the wrong set of facts to judge this. And then as soon as they awarded those grants, I literally emailed FFRF and said, well, they just awarded the latest round. Let's go ahead and file.
And there was one of the freeholders was on your side as well, right? That spoke out and said, I don't think this is legal.
He kind of did. I mean, Freeholder Alliance originally said that. Got an earful from the community. Probably got an earful from the Morris GOP, which basically runs the freeholders. All 9 of them are Republican. So he probably got an earful and just caved.
Yeah, and I guess to steelman the other side, you can understand where people come from if they're not thinking about the religious liberty angle. They're just saying, well, these are historic buildings, right? These are old buildings. It makes some sense for the county to be paying for their restoration.
Sure. I mean, I'm a huge history buff, and I love the idea of preserving history, but not at the expense of violating the Constitution. And that's basically what we said when we filed at the trial court level. We filed, and then the judge actually ordered us. We only filed against the county. The judge ordered us to bring the churches who were getting funds into the lawsuit. So we joined them as defendants.
Which gave our local counsel, Paul Grosswald, who is just tremendous help throughout this entire case, the thankless task of having to drive around the county and serve every one of these churches.
And the trial court bought the argument that you were just talking about more than the constitutional argument. Essentially, the trial court said, hey, you know what? Historic preservation is important too, and we're just going to harmonize that with this constitutional provision, which could not be more clear.
Yeah.
Right? It could not be more clear.
Judge Goodsite made some incredibly spurious arguments in her questioning and both in her ruling when she made the fund grant akin to providing, fire and police support. But the last time I checked, the police department or the fire department is not repairing the building after they put out the fire, right? So that's kind of the crux of the argument is the funds are being dedicated to repair, which is directly contravening the plain language of the Constitution, which thankfully the New Jersey Supreme Court, picked up on and clearly ruled on.
Yeah, and there's two other facts that are critical in the case too. And one is that the churches were not just seeking that money for historic preservation. In their grants, the churches themselves were saying, look, if we don't get this money, we can't continue to worship.
Yeah.
They were specifically saying that the money would go to their religious worship. So that was one really important point.
And the case doesn't turn on that, of course. I mean, the onus is on the government to look at what are these funds doing, and if the funds are repairing active houses of worship, active churches,
that should be enough.
Then that should be plenty to say, yes, this is directly supporting religion. But in case they weren't making that connection, the churches flat out told them the effect this will have is to advance our ability to worship.
Exactly. And the second fact that was critical was that this grant program was not available to everyone. It was only available to the state government, the county government, nonprofits dedicated to historic preservation, and churches. And if you look at the grant list, you can see quite a few churches on that grant list. It was $4.5 million in grants that we were challenging. So this wasn't a program that was open to everybody and that excluded churches. It was a program that was open to very few and included churches. So it actually favored churches, which makes it a little different than the Missouri Trinity Lutheran case that Ryan was talking about earlier.
Yeah.
So those three really critical facts. We have the religious liberty right lies with David, the taxpayer, not to be taxed and support a religion he doesn't agree with, the idea that these churches are using the money for religious worship, and that this is not a program that's open to everyone, but favoring churches. And those three facts made us say, you know what, let's keep going. Let's appeal this case.
Yep. And so, like David said, even though the trial court judge bought some kind of funny arguments that twisted the plain language of the Constitution, we were happy that the state Supreme Court, which took it on direct appeal, which is kind of unusual, they unanimously agree with us. That's a court with 7 different justices on it, and all 7 of them agreed that this is an obvious violation. Not only is it an obvious violation of the New Jersey Constitution, but also it does not run afoul of any of the free exercise concerns that were raised in Trinity Lutheran.
Well, let's back up and explain that a little bit more for people. But David, first, I just want to. How does it feel to win a unanimous case as the plaintiff? You're there in the community. You've gone to these boards to testify. Everybody's kind of shouted you down and ignored you. And then you have the New Jersey Supreme Court, every single judge on there saying, that guy is right. How does that feel? It's got to feel good.
Yeah, I don't know. We'll see how good it feels when I go to the next freeholder meeting on the 13th. It feels pretty good. I mean, it's nice to have ideas that I had about the nature of the constitutionality of this particular issue, which I raised to the freeholders on 2 separate occasions long before the justices took a look at this, basically repeated back in their decision and validated by the court. So it's always nice to be told you're right,
That's a very
it's
polite
also
way.
nice to know that other people, I think, irrespective of whether or not they agree with the outcome, that they're really being protected more now. And we have a government which is finally actually adhering to the plain language of the Constitution rather than flouting it.
Yeah, that's absolutely right. And this is good for everybody's religious liberty rights and, of course, for taxpayers' bank accounts as well.
And it's really a critical point that you brought up, because everybody does benefit from it. Catholics don't want to be funding the repair of Jewish temples. I mean, evangelical Christians don't want to be funding the repair of mosques. We non-believers don't want to be funding the repair of any religious building. This protects absolutely every single American. Now, Ryan raised an issue that he just mentioned that talked about the federal Constitution and the religious liberty right under the First Amendment. And that was one of the things the churches and the county were saying, look, this provision of the New Jersey Constitution, which says you can't give taxpayer funds to churches for repair, actually violates the U.S. Constitution's First Amendment and therefore the New Jersey Constitution is unconstitutional, which is a lot of constitutional syllable.
Yeah.
It's still amazing to me that the freeholders, to this date, basically say, wouldn't it be great if the federal Supreme Court were to invalidate a core tenet of the New Jersey state constitution that dates back to 1775? Like that, I find that completely astounding. That's effectively what they're arguing for. They're arguing for someone to tell them their constitution is unconstitutional.
Yeah.
And they argued for it at the Supreme Court. That's what they did. So after we won unanimously 7-0 at the New Jersey Supreme Court, which was back in August of 2018, I believe, then the churches in the county filed a petition for a writ of certiorari. Ryan, what the heck is that?
Yeah, so that's just a fancy Latin phrase that means they're asking the United States Supreme Court to accept and review the case. So,
but wait, why can't they just appeal to it like every other court? Why don't they just get to appeal to the Supreme Court and the Supreme Court decides the case?
The system, the way that it works is that the U.S. Supreme Court only selects a very few cases to pick that they're going to review. It's not like other appeals courts where you have a right to appeal. So you have to write this writ of certiorari to the U.S. Supreme Court saying this is a case that is worth your time, your very limited resources to review. And so the vast majority of these writs get denied, but there was clearly a lot of...
they only take like 80 to 100 cases out of, I think, about 2,000 or more.
Every year, yeah. But there was a lot of push, obviously, for this one to get accepted by the Supreme Court, and especially it got what's called relisted over and over again. So people were getting a little bit nervous that clearly the court was talking about it. They were
and actually,
it.
I was at the Supreme Court last week for the oral arguments in the Bladensburg case and did a very shaky selfie video in front of the Supreme Court for Ask an Atheist. And I was in line. There's a line for attorneys who are members of the Supreme Court bar to go in and watch the oral argument. And I was there at 5:45, and I was in line with a lot of our opponents on these types of cases. And a lot of them were talking about Morris County and excited about the opportunity to rip open this case before the Supreme Court.
Yeah, you said that's how they phrased it, right? Was this was going to rip open Trinity Lutheran? So they're looking at that earlier case, which again involved a church-owned playground as part of this neutral program. So it's a different set of facts, but a very concerning case for people who watch state-church separation. And they were excited about Morris County as a case that they said would just blow that out of the water and just basically open the floodgates for taxpayer money to flow directly into church coffers.
Now, so we've gone over everything so far. We're at the Supreme Court. The county and the churches have asked the Supreme Court to take the case. We know we got a big victory, so explain how this was a victory now.
Yeah, so what happened here was that we were able to file a brief, and we worked with actually one of the most prominent constitutional scholars in the country, Erwin Chemerinsky.
He literally wrote the constitutional law book that I learned constitutional law from.
Me too. I think more law students than not in law school. You take con law, you read Erwin Chemerinsky's book. He literally wrote the book on it. And so he was working with us, and we wrote a brief to the Supreme Court saying there are a bunch of reasons why you should not take this case. And fortunately, we convinced them. So we had it was a unanimous decision not to accept the cert petition, meaning that the U.S. Supreme Court will not rehear the case, so the New Jersey Supreme Court unanimous ruling sticks. So that's a final victory for FFRF in this issue.
So David, you convinced all 7 justices on the New Jersey Supreme Court, kind of convinced all 9 justices on the U.S. Supreme Court. That's pretty good. That's not too shabby.
I'd say so. I think I had a little help along the way, but yeah, it's a pretty good outcome.
Now there was a quirk in the denial of cert, which is the victory there. Justice Kavanaugh now.
Yeah, freshman Justice Kavanaugh.
Yeah, it was very strange to see him on the bench for a number of reasons when I was there for the Bladensburg argument, but we'll pass over those for the time being. And just talk about what he did along with the denial of cert.
Yeah, so Kavanaugh wrote a separate opinion that was agreeing with the denial of cert, so agreeing not to hear the case, and this was joined by Justices Gorsuch and Alito, but he explained a few things of specifics why he didn't want to take the case that were very concerning. So here you can say that he's saying that one of the reasons that he doesn't want to take the case is because the factual details of the Morris County program are not entirely clear. In particular, it's not evident precisely what kinds of buildings can be funded under the Morris County program. Now, we have to just stop and say that is not factually accurate, right? That is just false. In this case, we had a set of stipulated facts. So we actually worked with the county attorneys and the church's attorneys to agree on, here's a set of all the facts everybody agrees on, both parties agree. There's no disputed facts whatsoever.
And we spent a lot of time doing that at the beginning of the case, and this is one of the reasons that we spent so long with David getting the case ready before we even filed it, was because we wanted to know all those facts in advance, have the best lineup of facts, and know where all the facts that were most favorable to our case were, so that we could make sure they were in the record. And I mean, that preparation, it was long, but it really paid off in the end.
Yeah, absolutely.
So Kavanaugh was being a little less than truthful when he talked about the factual vagueness or the muddy waters in this case. The facts were absolutely clear. The problem was that the facts weren't what he wanted, because he made it very clear that he wants to overturn this decision of the New Jersey Supreme Court.
Yeah, he was clearly not happy with that state Supreme Court decision. And I think what was going through his head was just a matter of, he said, well, look, if we take this case and we overturn it and, rip open Trinity Lutheran the way the Christian right attorneys want us to do, then this is going to look so bad. It's going to be so obvious that we are just throwing this fundamental principle out the window in order to give more money to churches. And so he is, I think, kind of signaling to people to say, give me a cleaner case that we can pull this off without looking quite so bad.
Yeah, I mean, to me, that just showed how opportunistic the conservative bloc on the Supreme Court is. They pitch themselves as these principled conservatives, but really they're opportunistic. They're looking for a way to overturn this core principle in American jurisprudence and political science, that taxpayers cannot be coercively taxed to support a particular religion. So David, I mean, that was a big win, but a little bit of maybe a sour note on that. What do you think of Kavanaugh's opinion?
What do I think of Kavanaugh or his opinion?
Let's stick with his opinion.
His opinion, just his opinion. Okay. I think you're dead on. I think he's really tipping his hand to say, if you give a different set of facts, if you had a more neutrally executed program for which you could have a more clear, line of argument to the First Amendment, that would play right into his hands. I think it's completely disingenuous the way that he framed the Trinity case. It wasn't about the unconstitutionality of the Missouri Constitution. It was about an unconstitutional application of law in a particular set of circumstances. So, right. Circumstances matter. I think, his claims to want to, adhere to precedent are clearly not accurate. I mean, he'd be overturning Nyquist in this as well. So even though Nyquist, fell and said the program was okay, the one clause that they said was not okay was that they had this 20-year covenant of secular use, and it hinged on that being a 20-year covenant. They said, well, if it has to be a permanent covenant on secular use, so it still hinges upon the secular versus sectarian intent
and that's
of use of the money.
The recency of the precedent that he relied on is a good point. For the most part, all the precedent that he cited in his favor was from the late 90s or later. There's the McDaniel v. Patty case, which he cites from the 1970s. But really, everything he's citing is this new wave of court decisions that have been heavily influenced by the religious right. And this argument, you're right, it would throw just more than 250 years, really, of precedent under the bus.
Yeah, and I think it's worth noting that actually it was in the Trinity Lutheran decision that Justice Gorsuch actually pointed out the problem with the approach that they tried to lay out there, that it's going to lead to tough questions that, if you had a cleaner program, you would say, oh, maybe there is a way to twist this into saying this is religious discrimination, because how do you make distinctions between religious use, and are you just discriminating against churches because they're religious, or are you forcing taxpayers to fund religion? And he pointed out that's an unworkable problem. There's no easy way to parse that out. And the thing is, the Supreme Court knew that in the 60s and 70s, and that's why we have those cases from that era that were very clear. They drew bright lines that said you can't be funding religion. And so Trinity Lutheran blurs that. And of course, unfortunately, it should just be said that Gorsuch's solution is to go all the way the other direction, pretty much say, let's just allow funding of religion.
Well, and I think we've talked about Trinity Lutheran a lot. I don't want to get too deep into the weeds on that case, but if you're interested, go read up on Trinity Lutheran versus Comer on FFRF's blog, Free Thought Now. I've written a couple pieces about why this is a very, very bad decision. It was a good case for the other side to bring because this basically involved resurfacing playgrounds. So everybody was picturing kids getting their knees skinned, right? And kids crying because they're falling down on the playground. Nobody wants that to happen, so we're going to let this church school have money to resurface its playground. That was basically the case. By the end of it, all the parties, the state and the church, agreed. There was absolutely no adversity in the case, which should have made it go away immediately, but the Supreme Court heard it anyway. And then they didn't even examine the idea that you can't give public funds to churches under the First Amendment. They just looked at the religious liberty issues. It was a really bad case, and as precedent, it is seriously flawed because of those flaws in the opinion. But you should go read up on that. I think we're about halfway, or we're about at the halfway point, so we should start taking questions.
Yeah.
So, go ahead, Ryan.
So there is a quote that we managed, I know, to work into at least one brief that
very
we
proud of
love.
this moment.
Yeah, so Benjamin Franklin has this glorious quote that relates to this issue when he was thinking about it. Do you want to read it?
When a religion is good, I conceive it will support itself. And when it does not support itself, and God does not take care to support it, so that its professors are obliged to call for help of the civil power, 'tis a sign, I apprehend, of its being a bad one. So essentially, Ben Franklin is saying that, hey, church, if you need taxpayer money, you're not doing something right. God's not taking care of you. You're probably a bad religion.
Nowadays, we just say thoughts and prayers. To get to the same point.
So, David, can you stick around and take a few questions from our viewers?
Yeah, sure. Glad to.
Okay, so Morgan D asks, have you won cases like this before, like in Sitka, Alaska, or is this a more sweeping victory? I think that refers to the letter you wrote, actually.
Yeah. So I wrote a letter to the city of Sitka, Alaska, involving a very similar issue where they had an old church, and they said, we're going to give all this money to the church. And fortunately, that particular issue did not involve a whole trip to the U.S. Supreme Court to resolve.
Yeah, we were able to stop that. You were able to stop that with a letter. We didn't have to have a lawsuit. We've had a number of those victories. I stopped a exact same grant like this going to a Marist building in Tucson, Arizona. Would have been, I think, almost $1 million. Mm-hmm. They were going to repair this. The Catholic Church had a building. Like, the Catholic Church can't afford to repair their own buildings. Right. But so this is definitely a bigger victory. One, because it's with the New Jersey Supreme Court, and two, then the U.S. Supreme Court punted on it. So that's
so it clarifies the limits of Trinity Lutheran to an extent, and then also, throughout New Jersey, this is now the law of the land. So any New Jersey county that gets the idea that, let's give some money to this church, there's now this case on the books that directly stops them. So.
And David, you're keeping an eye on that, right?
Absolutely. I'm actually going to the freeholder meeting on the 13th to go and make my presence known.
And there is an interesting postscript on here too, because there were a couple of grants that the state gave after this that went to quote unquote churches, but they're no longer used as churches. They're old church buildings that are being used as community centers. And we don't have a problem with those kinds of grants or preserving that type of history.
Right.
And neither did the state and neither did the New Jersey Supreme Court.
And nor would we have a problem if there were a church that owned a totally secular historic building. If the church said, we have this old historic building that we're going to maintain as a historic museum and there won't be any religious activities there, we would say, yeah, you can go ahead and the county could pay to maintain that building because you're not advancing religion in any way. Mm-hmm. And so that just harkens back to how disingenuous it is when they try to twist this and say, well, you're excluding organizations solely because they're religious. That's just not the case at all.
So there's another question that we have here. I understand that there are some lawsuits that are forcing plaintiffs to be identified in church-state separation cases. Have you faced any such discrimination? Would you consider filing additional lawsuits in the face of such discrimination?
Yeah. So I wonder if this is someone who saw there's a lot of coverage of last week. I actually drove down to Jefferson City, Missouri, because there's a bill there that would take away the ability of judges to let plaintiffs pursue the case anonymously. And so I don't want to go too down the rabbit hole, but the short answer, I think, is that in most lawsuits like this one, the plaintiff has to name themselves. So David Steketee is out in the open. He just said, I'm the taxpayer, I'm the one bringing this lawsuit, and I'm the one who wants my constitutional rights vindicated by the court. In other cases, there are situations where there is a very real danger to the plaintiffs. And so we will sometimes go to judges and say, can you please, especially in the case of school children, for instance, can you allow them to proceed anonymously? And that's just a common sense thing to protect people who are in danger. And so in Missouri, they're trying to advance a bill that would take that away. So I think that's probably where the question stems from.
And all that bill is doing is trying to target people who bring these suits so that they can't bring them. Now, David, did you face any type of backlash from the community, any threats or anything like that for bringing this suit?
Not yet.
So that puts you actually in the minority because historically that is something that really, it happens a lot. Even in the Northeast, Jessica Alquist's case out of Rhode Island, she ended up having to go to school with a police escort, this 16-year-old girl, because she had so many death threats. So it's something that we see happen all the time, and it's one of the reasons I'm often asked, as an attorney going around, I go around the country sometimes talking about these issues, who are your legal heroes? And for me, the answer is always the people who are willing to put their names on these lawsuits, the David Steketees, the Jessica Alquist, the people who are willing to stand up and fight for that constitutional principle, no matter what their community does to ostracise or threaten them. And
I grew up in Missouri, so I, had I brought a case like this, I might have had second thoughts. I mean, I grew up in a fairly liberal part of the state outside of St. Louis. But man, had I been in like Columbia, Missouri or Rolla, Missouri, or where I went to school, it would definitely give me pause. It's a pretty serious issue.
Yeah, by the way, in Missouri, when I was down there testifying, the counter argument that one pastor came up and made is he said, essentially, there are no violent religious people in Missouri or anywhere, what are you talking about?
History has shown religion to be very, very peaceful.
There was one comment on Morristown Green that was, drive him out of town.
Yeah.
Wow.
Yeah.
Okay, I already left, but okay.
Yeah.
So Corey Melton asks, does the denial of cert give us hope for the future, given how far right the Supreme Court has swung under Trump? What do you think? My answer is no. What do you disagree?
Yeah, I am an eternal optimist. I like to at least hope on this particular issue that Roberts, at least, who is scary way, the new quote-unquote swing vote, that he views this Trinity Lutheran issue as something as something that he takes seriously, to say we're going to ask the question
as the religious liberty issue of not using the coercive tax of power.
Correct.
To take money from citizens and give to.
Yes, and asking the question, when you have this grant, are you denying the grant to an organization only because it's a religious organization? Or are you denying it because the money will in some way advance religion? And if you're honestly asking that question, I think that will, it should shut out the vast majority of money that's going to churches, because of course it's going to advance religion. So if Roberts takes that seriously and says, yeah, this is only a rule for the very tight circumstances that we pretended was going on in Missouri at the time, where you have a totally secular project that happens to be owned by a church and a totally neutral program, that's the only time that you are allowed to give the money to the churches. So I can hope.
Well, Corey, the reason that I'm more worried than Ryan, or maybe not, is I've been doing it a little bit longer. Maybe I'm just more jaded. I don't know. First of all, there's a significant amount of time left in Trump's first term, where we could see a justice off the bench, who knows what that will do. But the statement that came along with this was a very clear signal that we want to overturn this principle, but we can't do it with these facts. Which I think goes to how long we prepared for the case and how well we prepared and brought the case. They couldn't do what they wanted to do because of the case that we crafted, but they want to be able to do it.
Yeah, and the other side of it, of course, too, that's very scary is besides the danger of the nation's top court, Trump is also just packing lower federal courts with judges who are incredibly hostile to state-church separation. So even though we have this sort of clear precedent, you could get bad lower court rulings, and your only choice is then to go to the U.S. Supreme Court, who might not be much better.
So, Aaron McDaniel asked a question that's related to this, so I'll tag on. Have we ever seen anything like this statement by Kavanaugh, Alito, and Gorsuch before? I mean, it's not unprecedented, not unheard of, and in fact, Kavanaugh wrote one a couple weeks ago.
Yeah, so it seems to be their kind of new MO to agree with the denial of cert, but to put in there a little message to say, hey, if you want us to take a case and give you the ruling you want, here's how you do it. So that was the case of...
That was the Bremerton,
in Washington.
This is Coach Kennedy, who would go out onto the field after all his kids were playing football. A coach at a public high school football program would go out onto the field and pray at the 50-yard line. And the Supreme Court decided not to take that case, which was a big win. But
yeah, so
he basically penned him a roadmap, is what he did.
Yep, so in that case, for complicated, silly lawyer reasons, they were appealing it on one particular grounds, and Kavanaugh basically told them, if you would just ask us to review the other argument, we would love to do that, but the way that you framed the question, we have to say no. So yeah, that's very scary.
Okay, so we have one more question, it looks like, from Ari Randolph. What would have happened if the New Jersey Constitution was found to be unconstitutional by the Supreme Court? Would New Jersey have to get a whole new constitution because of this one case? No.
Yeah. If they had accepted the case and ruled that the New Jersey State Supreme Court violated the free exercise clause, what that would have meant is it would have only impacted this one particular clause, what we call the no aid clause of the New Jersey Constitution, and it wouldn't even strike that out of the Constitution. It would just mean under this particular circumstance, you can't apply it this way.
But it can't be interpreted in the way that the Supreme Court interpreted it.
And that would have been a major, major blow, and would have opened the floodgates to a lot of money going to churches. But it would not have invalidated the entire state constitution.
Yeah, I mean, I did the math for this case after we won, and if you add up the counties and how much money they're granting and, multiply it out over, say, a decade, we're talking like over $1 billion, I think was the final. I mean, this is a lot of money that's going to historic preservation of churches. Historic preservation of churches.
Right.
They're actually churches. I don't need to do air quotes around churches. So, David, any final thoughts before we head off?
No, I just want to, of course, thank you guys. I know it's been a ton of work on your end, and Paul, of course, here locally, and Edwin, who I now need to send him a copy of his book to get him to sign it for me, and I'll put that on my shelf.
Yeah. All right, well, you've been a wonderful plaintiff the whole way through, so thanks for your activism from start to finish and for sticking it out the whole way through.
We really appreciate it, David. Couldn't have done it without your courage, so thank you. You're
welcome.
And before we head out for today, we actually have another special guest joining us from somewhere in an airport in who knows where, because he's been traveling all around the country. We haven't seen him in the office it's been, I think, 3 or 4 years
quite a while
now.
Yeah.
Dan Barker, are you there?
I am in the Spokane airport right now. And you're right, I left, 10 days ago on a huge tour. 10 speaking events in 12 days in 6 different states.
That's incredible.
So today I'm flying from Spokane, Washington to Texas, Arlington, Texas, to speak to the Freethinkers group there. And then back home. I'll see you guys on Friday.
Where else have you been? Were you in Alaska too?
Yep, I was in Alaska. I started in Chattanooga, then went to Georgia, then went to Alaska. And a huge group in Alaska. Alaska has just a bunch of humanists, and they bought all my books. So I didn't have any books left to bring down to Spokane. But I got to see the ceremonial start of the Iditarod dog sled race on Saturday. That was cool. And we went down to the Kenai Peninsula. There's a group of freethinkers called Last Frontier Freethinkers. Who were challenging invocations at the city council, at the borough council. So that was really a lot of fun. So, and then I was at the Spokane chapter on Sunday. They had a huge turnout, standing room only, and they were disappointed that I'd sold all the books.
And is that what you've been talking about, Dan? Have you been talking about the books?
Well, I've been talking about 3 different things. Mere morality, that's one of them.
And that's your new book.
But most of the talks are about the battle of church and state. So it was really fun Tuesday night in Idaho. I was in Idaho, Coeur d'Alene last night. It was really fun to announce our victory on the New Jersey lawsuit. They were happy.
And we just got finished talking about that. That was it's pretty exciting. Ryan and I are feeling very good about that one. So the battle of church and state and mere morality, and then just kind of getting the crowds excited about FFRF and state-church separation.
Yeah, and especially they have a lot of questions about what does the First Amendment mean, what kind of work do we do, how can we help, and what's the demographics in the country right now, especially among young people. So it's really exciting. But the Spokane chapter is wonderful. But I was so surprised by the Alaskans. They are so thirsty and hungry to make some change up there. So that was really exciting.
Well, you do a lot of debates. It must be nice to have nothing but friendly, supportive audiences for a change.
Yeah, they were good. There was one heckler in Kenai, but next week I'm going to Phoenix, and then the week after I'm doing a debate in North Georgia. So it just keeps happening. Well, you guys travel too, so you know how much fun it is.
Not as much as you.
No, it's a good time, but I've never had a tour like that. That is, where in the world is FFRF Dan Barker?
Yeah, but Andrew, when your book comes out, you're probably going to get pounded with invitations. So,
we'll see.
Coming up.
Yeah. Well, good work, you guys. I got to sit in, yesterday on the legal meeting to discuss strategy and future lawsuits, and what a great team we have there at FFRF.
Yeah, that's for sure.
Well, we appreciate you taking the time to check in with us, Dan, especially from the airport before you hop on another plane to go who knows where. I don't know. We got to bring that map back up so we can keep track of you.
Yeah, today, Salt Lake City to Arlington, Texas.
Wow.
So I'll be talking in Arlington, Texas tomorrow.
All right.
So there you go. Somebody figured that out. Look at that.
There you go. Well, safe travels, Dan. We'll see you back on Friday, I guess. Welcome. You can come back to the single-digit temperatures.
Right.
Yeah, come back up. Yeah, okay.
All right.
Well, good luck, you guys. Bye.
All right, bye, Dan.
So there's the map of traveling Dan Barker's, I don't know, ramblings, I guess. But that is going to do it for this week's episode of Ask an Atheist. Thank you so much for joining us and for supporting the Freedom from Religion Foundation and the work we do to keep state and church separate. Join us for another episode next week.